So judgment item one. So we have interfered with the sentence from life to 20. Item two. Trial court judgment is upheld. However, we direct that he should be sent for medical examination. And if he is found to be of unsound mind, then he should be put in the psychiatric wing of the hospital, or not. If not, in terms of the Act, Mental Health Care Act, he should be put in a hospital. If found to be of unsound. Huh? Item 13. Yes, what about it? Okay, Miss L. Devi appearing on behalf of
Mr. RKD Chaudhary.
R.K.
RKD Chaudhary.
R.K.D. Chaudhary. Learned DSDY. This is the matter after? Three.
My lord, I beg to mention item number 3, my lord.
Three, yes.
But the concept of the other side, my lord. I am appearing on behalf of Mrs. A. Bhattacharya for responsibility, my lord. She has been admitted to hospital, my lord.
Okay,
And the will be adjourned for
okay, right. Any objection? Mr.
DK Roy.
D.K.
Roy.
Roy submits that Miss
A. Bhattacharya.
A. Bhattacharya, Mrs.
Mrs.
A. Bhattacharya, learned counsel for the respondent number
3.
3, has been hospitalized. He accordingly prays for adjournment. The same is not objected to by Miss L. Wrong PP, learned counsel appearing on behalf of Mr. S. Dekha, learned counsel for the petition. This is the matter after the vacation.
My lord, similar prayer in item number 12.
12 also same. Okay, in item 12, what is your name? Miss N. Upadhyay appears for the petition. Miss N. Upadhyay appearing for the petitioner submits that she has got no objection to the same. Huh? Same thing.
Yeah, please, Your Lordship. I beg to mention item number 11.
Huh?
I beg to mention item number 11. Your Lordship.
11.
Yes, Your Lordship directed PDCL to obtain instructions as well as to place original records of a conflictual bill relating to 1996 and 97. So, Lordship may kindly grant some more time to place the original records of the case, Lordship.
Who is the counsel for the petitioner?
Lordship, I could not contact them, Lordship. I don't
You
know.
wait, we'll adjourn it, but then since he'll be surprised otherwise.
Lordship. Okay.
Contempt matter, they have taken time to fight.
When did you file your affidavit contempt?
Contempt, we have filed in
May? No hurry.
there is a direction, my lord, which they have.
You wait. Huh?
Right.
Next week.
Wait, please, Your Lordship, in item number 4, we have filed additional affidavit yesterday. That may be called for, Lordship, for the matter.
Item 4, okay.
Yes, Lordship. Obliged, Lordship.
Right.
Matter regarding? Okay. Yes. Ah, okay. You are appearing for whom? What is your name? Mr. L. Sanktam appearing on behalf of? Your name is not in the Vakalat. On behalf of Mr. A. Sharma. A. Sharma is also not here. K. Kalita, learned counsel for the petitioner, submits that an attempt to settle the matter out of court is being made. He accordingly prays for adjournment. Leaves the matter after the vacation.
For listening, next matter for listening on Thursday. It's a matter relating to tender matter.
Thursday. Why Thursday? Settlement is going to happen. Thursday. Okay, no problem. I don't know why you didn't ask for tomorrow. Only notice, that's all. Nothing is sure. We have to hear the other side. We don't. It is only your allegation.
My lord, my only, now, once the, my lord, this is, at the end of the day, this is an IMF's fault, my lord. Once the settlement order is out, my lord, the things will, again, we have made him a party, we'll go trustee service, at least till date, my lord, because vacations are also coming, my lord. Once that is, my petition will become infractor, my lord. Only, my lord, I can understand if it would have been some essential commodities or something of that sort. At the end of the day,
You've got no right to do business in alcohol.
my lord, the same goes for the, what I have a right to be treated equally.
Correct. We don't know whether what you're saying is correct or not.
My lord, if it turns out to be false, my lord, then they are always at liberty to cancel whatever order, my lord. But at least, my lord, if so that the petition,
Who is for the excise?
we have served the copy also.
Huh?
Only till, my lord, only status quo, my lord, your lordship.
I can call them.
Yes, please call them. He is praying for a stay. After some time. No, I'm not. Little bit maybe.
What has happened is we have actually verbal instruction from the petitioner's son that a couple of months back petitioner expired. But due to some procedural issues, that certificate has not been issued. So what should be allow some time at least receive written instruction because without.
You see, if the petitioner has expired, nothing remains. It is not, you cannot inherit a public, this a PDS license. There is no question of inheritance.
To apply.
You have to apply afresh. So if he expires, then nothing will remain.
Sometimes that is properly sure that. Yeah, that's fine.
Huh?
Yeah, that's.
You have said he's dead, so we have got nothing to doubt you. I don't have anything to doubt you. You see, once he is expired, there's no question of the PDS being continuing in the name of that person. You can apply, the sons can apply. That's a different issue. But then this case has become infractor. There's no point keeping it pending just like that. What will happen at most? You tell me what will happen. Supposing you get instructions, what will happen?
Then we think.
What instructions can you get?
I think that actual death certificate
Huh?
will get issued.
It's okay, we accept your submission. There's nothing, Mr. Counsel, you just think of it. Right? If the petitioner who has been given a PDS license has expired, his cancellation was, his PDS license had been cancelled. Now what remains? Even if supposing we were to hold that the cancellation was wrong, then where is the question of the PDS license reverting to him? He's gone, he's finished. Whether a family can inherit, I doubt. Family cannot inherit. There's no question of inheritance. What remains? Because you see, there's nothing. They don't inherit anything. They don't inherit his liability, the cancellation, nothing. It's all now of academic interest only. If we decide, if we have to consider whether the cancellation or the suspense of the suspension of the license was correct or not.
Yes. Set aside. Probably some.
But why should it be set aside? There's nothing. That's what I'm trying to say. Why should we go into that aspect? Because you cannot take the benefit. The person has died. Son cannot take the benefit. There, there is no such thing of inheritance of a license, PDS license. You can apply. There's no question of inheritance. Order of cancellation of 2016.
Gotcha.
Now is 2024. Nothing will happen. Right. Heard, Mr. NZ Chowdhury, Learned Counsel for the petition. Also heard Ms. U Das, Learned Counsel for all the respondents. The petitioner's case is that you take this order dated 31/1/2017. Second paragraph, third paragraph. And second, third, fourth paragraph. Okay. I put it in red. Okay. Next paragraph. Mr. NZ Chowdhury submits that he has received information from the family of the petitioner that the petitioner had expired some time back. Yes, sir. He prays for time to obtain further instructions in this matter. Yes, sir. Ms. Udas, the learned counsel for the respondents, submits that as the petition has expired, the writ petition has become infructuous. I have heard the learned counsels for the parties. Yes. As can be seen from the pleadings and the order dated 31/1/2017 passed by this court. The petitioner was a PDS license holder. However, the license was suspended in the year 2016 and cancelled on 26/10/2016. The challenge to the suspension and cancellation of the petitioner's license has been made by the petitioner, who has now expired, who has apparently now expired. In that view of the matter, this court is of the view that the case appears to be infructuous. The reason being that even if this court was to decide as to the validity of the suspension and cancellation of the PDS license, the same would only be of academic interest. Further, even if this court was to hold that the cancellation of the license was bad in law, comma. There being no provision for inheriting a PDS license by the legal heirs of the petitioner, comma. A decision with regard to the issue raised in the writ petition would not be relevant to any person. Full stop. In view of the reasons stated above, comma, this court does not find any reason to keep this writ petition pending any longer. So the same is accordingly dismissed as infractions. The PDS, you give the full form. The public, public, huh? The distribution system, is it? Or shop? No. Shop or system, madam?
That's called, yes, public distribution. Public distribution system,
System, okay, system, huh?
so, yes, so,
Okay.
that shop.
No one appears for the petitioner on call. Who appears? Mr. S.R. Barwa
Yes, yes.
appears for
All,
all the respondents.
no, yes.
Yes.
No, from 1 to 3 and 4, Lordship.
1, 2, 3, and 4.
4.
1 to 4. And who is the 5 is who is 5?
5, some people.
Okay, no one appears for the respondent number 5. The petitioner is aggrieved by the resolution dated 29/2/2017 adopted by the specially constituted committee to define and redefine the river fishery mahals falling in the district of Tinsukia, more particularly the decision requiring the members of the fishermen community to be a part of the Dibru Saikhowa National Park Fishermen EDC. By the aforesaid decided by the committee that the entire fishery falls under the eco-sensitive zone of the national park and hence, commercial activities would be restricted therein. Full stop. By way of an additional affidavit, the writ petitioner has brought on record an order dated 16/1/2017 issued by the Office of the Deputy Commissioner, Dibrugarh, by which the concerned fishery has been settled with the petitioner for 7 years. Full stop. As such, the petitioner's rights to operating the fishery for 7 years cannot be disturbed. Full stop. The further case of the petitioner is that the members of the petitioner society cannot be compelled to take membership of a private entity in the name of, inverted commas, Dibru Saikova National Park Fishermen, EDC, inverted commas. Close. Full stop. Next part. As can be seen from the additional affidavit, the settlement of the fishery with the petitioner expired in January 2024. In any event, the petitioner is not represented today. The petitioner was also not represented on the last date, that is on 16/9/2024. It appears that the petitioner is not interested in pursuing the matter, inasmuch as the settlement period of the fishery is expired. The writ petition is accordingly dismissed for non-prosecution.
If that minutes date is 29/7.
Huh?
29/7/17, minutes date,
Minute, okay?
date of the minutes. That meeting, date of the meeting of the minutes.
Have I said that? Okay, 29/7/17.
17. Of like,
Non-prosecution.
The petitioner has filed an additional affidavit bringing in new facts with 2 annexes, my lord. We need to reply, my lord. After vacation.
Relying on that. But this is, matter is covered by 2 divisions and judgment of the court. Now, this is a matter related to carriage. My lord, the FCI to the tender. My lord, you will also find at page 48.
Page?
Page 40, correct judgment.
Asha, you are not relying on what?
Yeah.
You are not pressing, I want to reflect that in the
That
order.
may be recorded, my lord.
I have to record that.
Yes, my lord.
No, I have to record that, no. He is not pressing the averments made in the additional affidavit. Additional affidavit dated 23/9/2020.
However, page 40.
Yes,
Page 14, item number 4, my lord. It is, my lord, the release content. Tax railway signing, Kalchapra to FCI SSB from the book via Webris, 10/6/2/1950. Accordingly, my lord, now it will also come to page 62, my lord.
yes.
Things, my lord, that's all that's will be treated and armed for a single person.
Just a minute, just a minute. Yes,
The
page
last
62.
one, page 62 last.
Yes,
All that will be treated as for a period, but what they was doesn't matter, tell me either, play, but I consider except that was the rest for transportation of the gains are the episode of.
net weight of food grains.
Now, this, four.
What?
Roman,
4,
For the purpose of calculation of transportation charges and distance, all cases are rounded up to near kilometer, the distance will be recorded. As fixed by the chief engineer and officer, nominated by him, and general manager verified so and so. On behalf of the, on that and rounded up to nearest kilometer, final and binding of the.
yes.
I don't know. Well, they have completed the, now they have issued the page 74. There we go.
Page 74. Yes,
Appointment of the Transport Contractor Act, which is findings are the to apply.
no, page 74 is annexure 4.
And
Yes,
it's heavy ground.
yes, saving club. Yes.
Appointment of Transport Contractor Act, salary finding are the
Where are you reading appointment of?
reference or tender number.
It says reference or tender number, so yes,
Or appointment of.
yes, yes.
Chapter,
Yes. Oh, you started from second line, that's why.
Yes, madam.
Please, you see, for us, we are first time we are seeing this. You've got to go at our pace. Yes. For appointment of transport contract is very 292 km. Number of road.
Kilometer on regular basis for a period of 2 years. Your total rate is rupees 759 per MT. Request to furnish so three things. Other things are not necessary, but this is they have issued our look at the actual rate 292 kilometers.
So your rate has been accepted.
Yes. Now, well, when we started getting the contract, well, we find that the distance is much more. Then we submitted at least 15 letters, my lord.
And did they accept?
Yes,
The-
they have accepted it. Then
Page.
They appointed a inquiry committee. And inquiry committee submitted its report,
Page,
page 89, annexes 60.
yes,
Well, the third column.
yes,
Here, my lord, from beginning, point Salsapra to Haya, Beverage, to Podapuka, so and so totally, they found it 343.23. Instead of 290.
so 51 kilometers difference.
Yes, my lord. So we have claimed that, my lord. So we filed a petition, my lord, that did not pay. In the meantime.
No, you filed a writ petition. Then what happened?
My lord, that was allowed.
Let us see.
One, any trade had filed a petition at page 93, your lordship find that was also allowed.
No, not you, some other person.
Some other person filed prior to us.
Okay, see, these cases are filed by other persons.
Yeah, it was the case filed by other person, it was allowed. By
Anything, okay, page 93 and
property portion is paid, 103.
103.
This is for my lord, another my lord case, where also my lord, the less distance was.
No, this is for one. You said there was another case.
Yes, that was another case. Now, our case is my lord, is not. Our case is my lord at page 108.
This is what with regard to this case, this contract or different
Same
contract.
contract, my lord, yes. My lord,
So it has been allowed.
yes, that
then-
was
then-
allowed,
Then
then my lord, they preferred the bid.
where is that page?
Page 113, my lord, property portion.
113.
Accordingly, the.
Yes, okay, okay, 343.2. Then what happened?
Now they prefer to appeal that but there is a grievance redressal committee, so alternative remedy is there. They have not approached that. So division bench said that, it should approach the grievance redressal committee.
So it set aside the single bench judgment.
And
That is at page
that is a page, the one.
114. 114 and where is the where is the impugned portion? Not impugned, the operative portion.
Party portion,
No, 114 is the appeal petition.
appeal. They prefer the appeal, against the charge.
Correct, but where is the order?
They prefer the appeal. And last is page 128. But this means, Dark similarity, yes. Well, at page 128,
Yes,
the respondent contractor will file a claim before the dispute, advance adjustment committee, which is executed and decided by provider. The prior to the of that.
no, where is that? It does not say you
Page
shall file,
128, but
okay, shall file a claim, yes. But where is the setting aside?
that is the paragraph 20. In view of the above, the appeal is disposed of, improved judgment hereby certified.
Paragraph 20,
Contractor may discuss.
paragraph 20. Paragraph 20. Oh, okay, okay. So it has been said again, so then what happened?
One parameter, here also, just note, it is of the dispute redressal committee on appearance of the matter which will adhere to the principle of good faith as explained above. There are some steps on it in that. Now we have submitted the, before the grievance redressal committee, matter, they did not dispose of, then we approach this for contempt, then the order has been passed.
Page? Page,
Passed, they have taken it out.
page.
Page is 144. Then again. you take-
Just a minute, dispute redressal committee. Is it committee?
Yes.
17,822.
Yes.
Rejected your claim. Then,
Pardon the bill, dispute again, at page 148. At 150, my lord, your lordship, with that.
yes,
There are two. The petitioner is allotted transfer work was sustained in respect of 292 kilometer, but when the actual work took place, transportation had to be done in respect of 340 kilometer. Accordingly, petitioner claimed that they paid the additional amount for extra kilometer of the work they had performed. The reading of the impugn order makes it discernible that state aspect of petitioner was required to perform transportation work for certain additional kilometer, which were not given a consideration while rejecting the claim of the petitioner. The respondent back a statement.
okay, then what happened?
Then, my lord, again, my lord, that we have gone to the National Committee, again it was, now we have an situation. My lord, in fact, my lord.
Yeah, page 151 is the redressal committee.
Yeah.
The grievance redressal committee.
Now, I said before.
So
my
this
lord,
is dated 15/11/22.
Yeah.
So you have come here.
Now, before that, my lord, I shall place two judgment of this court. My lord, if you lost it, division. In respect of similar matter.
No, actually, anyway,
Uh,
there was no requirement of going to that when the single bench is already decided.
my lord. And that- that's your lost it, my lord, my lord, two things, apart from the similar.
In different cases.
Different case, my lord, different level. Now, my lord, what happened? Now, after 8 years, they filed the affidavit saying that there is another alternative route. That which is less than 92 kilometers. And then, my lord, roads are being developed. That is what we have filed the affidavit reply. That cannot be taken now. Earlier committee had found, my lord, it have to dispute redressal committee, my lord, everything is said. Now they have filed in a writ petition after 8 years, my lord. My lord.
Yes.
It is your loss. Before coming to those judgments, my lord, may I just quote the relevant clauses of the tender document, my lord.
Yes.
I would like to take your lordship first of all at page 49.
This has become, it has just gone for a real merry-go-round, that type of ride, this case.
My lord, everything has not been placed. Let me place the entire facts, my lord.
What facts do you want? Basically, the issue is,
No, my lord, this
292, that's all.
already in this case, my lord, the in the writ appeal preferred by the FCI, that matter was settled and that has not been challenged. So that has attained the finality.
correct.
Only he has
So,
given, only the petitioner was given a chance to go for the GRC because.
so
the
that
petitioner
can be
has preferred-
challenged in a writ petition.
Because the petitioner has preferred that they wanted to go for a GRC and considering the submission and the
Petitioner
merits
did
of
not
the
want-
case, the
Why should,
Learned Division Bench
Mr.
has
Council,
set
just a
aside-
minute. This is not a shouting match.
My lord,
Okay,
I'm sorry, madam.
next time I won't even listen to you.
I'm sorry, madam.
Yes, don't think that just because we take it cool that we're very soft. Now you see one thing. You had gone in appeal, he did not go in appeal
Yes, madam.
before the
Challenge
division
is fine,
bench.
challenge
So why should he go when he has won the case before the single bench? Why should he go to the division bench and say that we want to go to the GRC? It was not, it never, it is your
there, my
case,
lord.
not
It
his
is
case.
there. Let me place the facts, my lord.
Show me.
Mr. But just I will take your lordship to certain clauses of the tender document, my lord, which is at page 48, my lord. NIT dated 33/2015, and the relevant part is at page 49, my lord.
Which page?
Page 49, my lord.
Yes.
Down below the, my lord, the NB, my lord, there is a NB.
Yes.
If the value of the contract is less than rupees 5 crore, this is not important. Thereafter, the one line, the rate should be quoted as per MT per kilometer as per the MTF. If the rate is quoted otherwise, it shall be converted to per MT per kilometer, taking distance as mentioned above, my lord. So, my lord, the petitioner has quoted the entire, for the entire distance, he has quoted the rate of 2759, my lord. Then, my lord, at page 52,
So you mean to say hmm, hmm, okay,
I mean
then
to say, my lord, the petitioner has quoted his rate for the entire distance at a lump sum amount.
well,
He has not
yes,
quoted,
naturally, because you have put it in your tender notice that it is 292 kilometers.
there is thereafter later on, it was found that by the another committee that the actual distance is 290 only, my lord. 290, my lord.
That's
Yes,
a
we have
different
filed in
issue.
our affidavit in opposition, my lord, the petitioner has not challenged those findings of that committee.
Okay, so it's 290 kilometers.
290 kilometers. And those roads was existing earlier time also.
Huh?
That road was existing earlier time also, my lord. Now
Maybe,
they are
maybe,
saying in
maybe.
the additional affidavit which was filed today, that now since the development has taken place, now these routes are.
You see, so the issue is this, whether it is 292 kilometers, whether it is 290 kilometers, or whether it is 343 kilometers, 0.2, I do not know. So that is the issue then.
My
That's
lord,
all.
my lord, kindly bear with me, my lord. I will
Yes.
take your lordship to the judgment rendered by the Honorable Division Bench, my lord, which starts from page 114, my lord. My learned friend is relying on the decision of any trade, my lord, which has been distinguished by the division bench. In this case only, my lord. Page 117.
Yes.
Page 117, my lord, para 7 is the facts
Yes.
of the case, my lord. Just I will read it on my, the contention of the learned counsel for the appellant FCI is that the case of the other contractor which was decided finally by decision rendered in WA 416 of Title Food Corporation of India versus any trade and transport, and another decided on 7/5/2019 is different in so much as in that case the rate quoted by the transportation per MT per kilometer. Under the circumstances in regard to the difference in distance, only the rate already quoted per MT per kilometer was to be applied, my lord. Whereas in the case in hand, the quotation given by the respondent is 2759 per MT for the entire distance of 292 per kilometer in terms of the tender notice. It is the contention of the learned counsel for the appellant that recalculation of the rate will have to be made for the actual distance for which the transportation has been made by the transport contractor, that is 343.2 kilometer, which exercises cannot be undertaken in extraordinary jurisdiction. It has been pleaded on behalf of the appellant that the scope of judicial review in matters of the contract has been dealt with by the Honorable Supreme Court in case of Jagdish Mandal versus State of Odisha and in the case of Sri Ram Builders. Now, my lord, and paragraph 10, so far as the judgment rendered in WA number 316 of 2018, that is any trade, my lord, is concerned, there is no doubt the rate quoted by that contractor was 11.41 per MT per kilometer. Only the only it was per empty per kilometer, whereas in such circumstances, in regard to the kilometer measured by the committee, only the rate was to be calculated. So in any trade, because the contractor has quoted the rate as per empty per kilometer, so it was allowed, my lord.
But here,
Whereas-
here he has not quoted that.
Here he has quoted for the entire distance 2759.
Correct, but he's not
So-
he's not quoted per empty per kilometer.
He has quoted 2759 mile. That is the admitted position mile. Thereafter, mile, next line. So
Two
far as
seven
the
five
case,
nine per empty per kilometer.
yes, mile.
Where is that? Where do you get that?
Paragraph 10, mile. May I read it again, mile, at page 118. So far as judgment rendered in WA 316/2018 is concerned, there is no doubt that the rate quoted was rupees 11.41 per empty per kilometer. In such circumstances, in regard to the kilometers measured by the committee, only the rate was to be calculated. So far as the case in hand is concerned, as noticed above, rate quoted by the contractor is not per empty per
Correct,
kilometer.
it's not per empty per km.
Yes, rather 2759 per empty for the entire distance given in
Correct.
is 292 kilometers.
Correct,
That was the observation of the learned division bench, my lord, honorable division bench. The
correct.
question that arises for consideration before this court is to whether the rate jurisdiction, the rate court should indulge in reassessment of the rate in a particular facts and circumstances of the case. My lord, thereafter,
There is no reassessment of the rate.
because he has quoted, my lord, for the entire distance, my lord.
Correct. He has not quoted per empty per km. If he had quoted per empty per km, then you had a case. But he's
No,
quoted for
if-
he's quoted for 292 kilometers. He is not quoted for 343 kilometers.
He has quoted for, no, my lord, his price bid says so 2759 for entire distance, my lord. That price- that
2759 per metric ton.
he had quoted in his price.
Keeping
price
in,
bid, he has
keeping
quoted
in view, keeping
by
in view.
striking off, my lord, by striking off per empty per kilometer, he has quoted 2759 for entire distance, my lord. Even in his appointment letter
279 per metric ton,
per metric ton.
but it'll be for only for 292 kilometers. It is not for 343 kilometers.
And thereafter, my lord,
You see, otherwise he's making a loss. Because then that additional 51 kilometers that he has to run has to be multiplied by this 2759. That is the thing. It's not very difficult to understand. It's like this. This book. You have made your quotation distance till here, till this 1872. So he has quoted his price from here till here, 1872 till 1872 as 100 rupees per
yes,
metric
my lord,
ton.
292 kilometers.
But then-
Let us assume
correct.
he has quoted for
But then
292.
now if it is 343, then-
But again, now it is now 290 kilometers. my lord.
that is a different thing. That
My-
now, that is
My
a
lord,
different.
yes, my lord. And that thing has not been challenged by the petitioner, my lord. Thereafter, my lord, in page 14, para 14 and para 16 of that writ appeal, my lord,
Yes,
we are of page 125, my lord.
just a minute. Just a minute. In para 118, in page 118, you wanted para
I have read, my lord, 7, 10 and 11, my lord,
7, 10, 11.
and 11, my lord.
Then
Then,
in
my lord, at page 125,
page 125,
para 14 and 16. We are of the considered view that the case in hand would not fall within the realm of the cases in which we as the rate court should interfere in particular facts and circumstances of the case. Now 16, my lord. So far as the calculation of the rate is concerned, because the rate quoted by the contractor was not per empty per kilometer, in the considered opinion of the court, the rate court would not go into the aspect and recalculate the rate, my lord. Thereafter, my lord, the finding of the honorable division bench at para 20, my lord. My lord, that's 17, my lord, 17 also, my lord. It will clarify, my lord. Being faced with these facts and circumstances, the learned counsel for the respondent contractor states that he would avail alternate remedy as provided under the retender. E-tender and approach dispute trader. It is not we said that they have approached them when they seen that the honorable division bench was going to dismiss it, but ultimately it was dismissed, my lord. At paragraph 20, page 128, my lord.
well, they had to do that. They have got to change their
No,
stance
I'm
since they
not-
were going to
I'm
do.
not harping on that, my lord. I'm just placing the facts, my lord. Page 128, my lord. Thereafter, in view of the above, the appeal is disposed of, the impugned judgment is hereby set aside. Whatever was set aside, my lord.
Now,
I would come to my affidavit in office.
now, first of all, let us be very clear. Now, the grievance redressal cell or whatever committee has rejected
Yes,
their case. Now, they have come again in this writ court. Anything wrong with that?
now, since now there was another committee during the pendency before the GRC, my lord. The FCI has constituted another committee to for the measurement, actual measurement. Then the measurement was done, my lord. At page 194, I quoted, but before that,
Page?
my page 194, my lord. Committee report, my lord.
Yes.
First line, in pursuance of FCI RO Assam Office order dated so and so.
No, where are you reading?
Page 194, my lord.
194. Okay, that is,
It is annexure B of the affidavit, my affidavit in opposition.
just a minute. This is in my copy, it is a paragraph of affidavit of respondents 2 to 6.
Yes, my lord.
Huh?
That is.
It is part of, it is paragraph 23, part
it
of
is
paragraph 23.
Paragraph 23.
It is annexure according to
It
you.
is annexure, my lord. Annexure
Annexure,
B.
annexure B. Annexure B of affidavit of 2 to
Affidavit
6.
affidavit in opposition filed by the respondent 2 to 6, my lord.
2 to 6. Annexure B. Annexure B, page 204.
I will correct.
Yes.
In pursuant of FCI RO Assam office number so and so dated 17/7/2023, the committee constituting the following officer has examined the matter related to the query raised by the Jado Annie, a white letter dated 23/2023 related to the personnel responsible for constituting the committee for the remeasurement of the distance after the award of the contract, my lord. Under the relevant paragraph, relevant part is at page 19. That will be 207, my lord.
207. Yes. Yes.
Yes, ma'am. The distance for the route RX Silchapara to Chandrapur as per the NIT was 292 kilometer, which was based on DO Silchar committee as mentioned earlier. This route was also part of the proposal for re-measurement of the distance as the transport contractor. Anup Trade and Transport sent representation to the FCI RO Assam claiming the distance to be inaccurate and hence requesting competent authority to verify the distance and let them know. The distance of the route, that was the earlier committee's observation, my lord. The distance for the route RS Silchapara to so is 334 has increased by 51.2 kilometer annexure as. How
Okay, 290 kilometers.
the conclusion, my lord.
Fourth paragraph. However, when examined,
However, when examined through maps and through map, the route of Silchapara to Chandrapur when followed through this Silchapara siding via Way Bridge, Badarpur Ghat, Silchar Division Point, Teliamura, FCI FSD Chandrapur was approximately 290 kilometers. This should have been the shortest motorable route as stated by the DO Silchar committee. So therefore, committee is of the opinion that the original distance of 292 kilometers as stated in the NIT could be considered as the shortest motorable distance, and thus the claim of the transport contractor is categorically wrong irrespective of the outcome of the later remeasurement committee.
so
my
what
lord,
to do?
They have found the ultimately.
And now they have found it 290, so they have set 292.
Yes, my lord.
Now what
My
to
lord,
do?
my learned senior friend is relying on the GB Chaudhary holding that we went to Supreme Court. Ultimately, Supreme Court has disposed of that. In fact, dismissed the but made an observation. Though we are not inclined to interfere with the impugned judgments, we leave the question of law open while making it clear that the impugned judgment will not be quoted as a precedent matter. That GB Chaudhary.
Anyway, I'm not on that right now.
My lord, the
I'm-
actual distance is 290 kilometer. My
That
lord.
is what. If it's 290, he has got no
290,
case.
my lord.
Now what to do?
And
This is a question.
this is a disputed question of fact, my lord.
Question of fact.
The petitioner should approach my lord civil court. my
Yeah,
lord.
but this will come, Malad. There may be various things. Your lordship find, in the first committee find it, page 89. Sorry, that is what we have, in affidavit also said. Hello, page 89. They are coming after 8 years, Malad, that their job has become.
Yes,
In the bottom matter.
yes,
There are three ways. Your lordship notice, Malad,
yes.
that led to main road, national highway via Kalai. But out of that, lorry trucks can.
No, no, where are you reading? There are three ways.
Last report, my lord, that.
Huh?
After the table.
After the table. Say that, no, you're reading wherever you want, then we have to look. Where are you reading? You please tell us
Sorry.
that you're reading at the bottom, you're reading at top, you're reading somewhere in the middle somewhere. You are reading what is now even supposing I start reading. Koyapur Highway Bypass, where is it?
There are,
I will also read whatever I want. You have got to tell me where you're reading. Yes,
there are three ways
yes.
that led to main road, national highway via Kalai. But out of that, lorries, trucks can fly only on one road. The other two roads go through a populated village area and private estate and not possible for trucks, lorries to fly via those two roads. Well, already they have answered it.
Now, I don't know whether this 290 kilometers is
Yes, ma'am.
which road.
Yes, my lord. Absolutely, my lord.
Your lordship see, in the tender, they have said 292 kilometers.
Correct.
Malad, thereafter, Malad, this committee was found in long back, Malad. They found that it is 343 kilometers. And all cases are disposed of on that basis, Malad, committee report.
I don't know now, since they have brought out this topic, we'll have to go into that. Since they have brought out this issue, we have to go into it. Now, you see, one thing is that when the tender was issued for 292 kilometers, it was your duty to ascertain at the first instance whether it was 292 kilometers or not. And you have accepted it with open eyes that it is 292 kilometers and you gave your rate. Now, subsequently, they have come with a committee saying that it is 343 kilometers. Now, that the 343, but then there is now another third committee.
That is, you
No.
want to see, Malad, that is after disposal of these so many cases.
No,
Malad.
I'll have to see all those. Let me see all those.
So, see, to see, Malad, that whether it's correct, Malad.
Correct. With that's what I want to see. Now, show me how do we prove?
Yes.
How do you prove that it is 343 and not 290 or 292? Otherwise, on the question that you have raised, I am leaning towards your submission, no doubt about it. Only thing is with regard to facts. Have you made any averment against this page 207
Well, yes, para 23, Malad.
of your additional affidavit? But you are not relying on it.
Earlier affidavit. One affidavit has been filed by the earlier on 6/11/2023.
611. 611. Yes,
Paragraph 20.
paragraph 20.
By denying the statement about the making paragraph 22, 23, 25. Of the affidavit opposition.
Paragraph 20,
Paragraph 23.
23.
While denying the statements made in paragraph 22, 23, 25, the answering the opponent fact declared that the respondent authority had not informed the answering the opponent about proceedings on any committee for remeasurement of the distance And answering the denied dispute the correctness of so-called committee report that is 11/8/23, which was done behind the back of the answering the. Father, it is stated submitted that NITH should be, in the, back in the year 2015, where in the Sebigam, it was clearly mentioned that the shortest motorable distance from Salchapra railway siding to areas FCI, FSD, including Chandapur, Tripura, 292 kilometers. After the committee report stated the actual distance is 343.2 kilometers and not 292 kilometers. However, the respondent authority will now, the ulterior motive not to compensate the answering respondent has come up with a different so-called report that is 11/8/23, stating that the shortest motorable distance are FCI Chandapur is factually wrong. And the shortest route passes to Teliamura Amarpur. Teliamura Amarpur was not there earlier. Teliamura Amarpur was not there. Higher NH 208, and the committee found the distance from RS Salchapra to Chandapur. Higher Teliamura Amarpur, at 298.
I don't know whether tell me out, that whatever the name is, whether it was there before or not, I don't know.
The committee report you have also see, page 89, if you will also see, they have given the max. Page
Okay,
89, if you will also come to page 90,
yes.
page 90, they have everything they have given, details.
So
Now,
this is the route.
90 and 91 also they have.
Yes, Mr. Counsel for the FCI. He says that this page 90 is the route. Is this page 90 the route or not?
Will take just 1 minute, my lord, just wrapping.
These are all questions of fact. Right? Anyway,
That is what my submission is, that let them approach the civil court, my lord.
wait. Not so fast. Is this page 90 the route?
That has to be verified, my lord, my.
That is their own report, man.
We'll give them one date, let them clarify whether this is the route. That's all. If they say that this is the route, okay, but if they say that this is not the route, then let them show the route. Otherwise, what to do? I cannot say, no, this is the route. I do not know whether this is the route or that is the route.
Yes, that after 8 years of the tender, they will again find out some new route.
I do not know. I do not know.
That road, no, we have categorically stated that route always existed and the earlier RO committee.
Three routes, who are not motorable.
Anyway,
That route may be.
no. You see, this is the problem is the issue that has been raised. Whether it is after 8 years or after 1 month or after 1 day. The fact still remains that it is a question of fact.
And then
Now, I cannot decide so quickly.
in that case, my lord, this subsequent affidavit may be considered, my lord, they want it there.
I will not make any mention now.
Subsequent affidavit means to file today.
Yes.
Then I may be allowed to file my
Yes,
reply.
you find a reply. But you also make it clear with
Yes,
regard to
my
this
lord,
page
my
90.
reply, I will also make it clear, my lord, after vacation.
Okay, right. I heard Mr. Jain Sahewala, learned senior counsel for the petitioner, as well as Mr.
BK Singh, my lord.
BK Singh for the FCI. Mr. BK Singh shall obtain instructions as to whether the sketch map of the route provided in page 90 of the writ petition pertains to the the ex railway siding Sal Chapra to FCI FCD Chandrapur bracket Tripura via Weybridge. Page 48 it is there, same number. As reflected in the tender notice dated 30/3/2015. The FCI shall categorically specify as to whether the route mentioned in page 90 is the route relating to the NIT dated 33/2015. If not, comma, the FCI should make a clarification of the same. Full stop. Mr. BK Singh is also granted 3 weeks time to file a reply to the additional affidavit submitted by additional affidavit dated 23/9/2024 issued by submitted by the petitioner. And this is the matter out of vacation.
Like that.
I heard so long.
Sir, it may get.
No, I'll forget. It's a small issue. It's a small issue. Only thing is with the question of fact, that route. Problem is that, you see, you bring your records. I think your records will show what is the route to be followed. Okay. Mr. BK Singh shall produce the records on the next day to show the route to be followed in pursuant to the NIT dated 33/2015.
Like.
Timing 60.
What is this? Actually, keep this in the cases. This also. This is the file. Yes.
Is they challenging this technicality of the right respondent, your lordship?
First of all, I want to know, it was his technical bit was
Yes, he's
responsible. He's qualified.
He is qualified when right respondent, when he is qualified, your lordship.
Huh?
If
Private
both the-
respondent.
Even
He
private
is
respondent-
challenging the private respondent.
Yes,
He's
and
saying that he is
that
not qualified.
If the private respondent goes up, he'll be the sole bidder in that.
Correct, correct. So whether he's given 2-3
My lord, it is similarly on the same district, in the month of February, there was a settlement in relation with another location. There also, my lord, the tenderer who has not submitted land revenue clearance certificate, which tender was rejected as an act. Secondly, my lord, one thing I'll show, my lord, that will prima facie clarify that there is something going under the.
no, something going under, so we cannot do it. It has to be clear as daylight.
Authority has the power, clause 19, deviation in terms and condition of bidder, they can deviate, your lordship.
I can understand, my lord, but deviation does not mean 180-degree U-turn. I will kindly see, we kindly come to page number 90. Page number 90 for a while. Now, my lord, page number 90 is an affidavit in compliance with the Eastern tender. My lord, will kindly see when this affidavit was sold. The date is 3rd of February 2024.
Where?
My lord, will see page 90, the date. when the
3rd
stamp
February 24, yes.
20. The NIT in question was issued in the month of July
Of?
2020.
So?
How can he swear an affidavit even before issuance of the NIT?
This is for what?
Yeah, now kindly, my lord, will see the statement he has made in this affidavit
Yes.
that we are qualified as per prescribed provision of Assam Excise Act 2000 and all this. Aware of the provision of the Excise Act, I declare that none of the directors, this is in compliance with the NIT. I declare that none of the directors have been blacklisted. And interestingly, that I have not been convicted in any criminal case or all. In February, somebody is swearing regarding something which will submit in the month of August. For 6 months, my lord, who will account for this 6 months? And the last para number 9 of this affidavit, I have truly disclosed the detail of shops for which the bid has been submitted by me. How on earth can a man swear this line in the month of February when the NIT was issued in the month of July and the tender was submitted in the month of August? This is one. Second, my lord, will kindly see at page number 95 first. This was your lordship has dealt in an earlier case also where I was putting a small. Page 95, clause number 12. what the bidders are required to submit? Valid lease agreement. Valid lease agreement has to be submitted. Now, what is the lease agreement which they have submitted? My lord, will kindly come to page number 82.
All these queries, your lordship, he didn't even raise before the authorities, your lordship. Directly, he approached the honorable court.
My lord, we don't have time because day before yesterday, my lord.
Even his bids are admitted.
My junior got it
Whoever
mentioned
bids the
yesterday.
highest, he'll get the shop.
My lord,
He didn't even approach the authority regarding all the anomalies which he had pointed on the
They
petition.
should not prescribe any technical qualification. Mere application by the bidder that I am technically qualified and submit the financial.
Yes.
Now, my lord, page 82, lease agreement. My lord, a lease agreement has to be registered under section 17 of the Indian Registration Act if the period of lease is more than 1 year. Now, what he has done, he has given a notarized lease agreement. And the period of lease, he have in a very subtle manner, my lord, we see page 83, para 1, he kept the period of lease as 1 year, but with a clear-cut rider that will be extended beyond 1 year after it expiring. So they are trying to circumvent the provision. Now, my lord, we'll also see page number 29.
We'll have to see whether these are essential conditions.
And second thing, it's a rebid, your lordship.
Huh?
This is a rebid. Previous bid,
You see, there are essential conditions, ancillary conditions. Now, who is going to say they are essential or ancillary?
Therefore, my lord, what I am bringing, my lord, because my lord, if your lordship passes its status was order on the next day, my lord, let them say these conditions are not essential, my lord, I'll go. Only to that extent, my lord. They have not. taken
Why haven't you filed any representation? Why did
My
it come directly?
My lord, we kindly appreciate, my lord, the financial bid, the technical bid was opened on
21-9,
page number 1111.
Annexure 5.
21-9. We are on 24th, my lord. Tomorrow, today they will probably in the afternoon, they will open the financial. My lord, we know, my lord, it is that.
So you are still there in the reckoning?
My lord,
Yes.
I know, but once.
Oh, wait a minute. I thought you said that they have already been. So, acha, you want his technical bit to go.
Because
Go.
I am pitted.
He will remain with
my
the sole
lord, I
bidder.
am pitted against a man who is.
No competition at
technically-
all.
No,
My
no,
financial
no.
bid is pitted against
Sorry,
a man
sorry.
who is not technically qualified.
I do not know. We'll have to give a chance to him.
Precisely, my lord, what I am saying, since it is not an essential commodity shop, my lord, with all, my lord, that let there be.
We'll issue notice, that's all.
My lord, let there be just end status, my lord, vacations are also coming, my lord. Let there just be status quo, my lord. Let them produce the record and say, these are, he has complied and these are not essential, my lord. My writ petition may be dismissed, even some cost may be imposed if any of the allegations which I have fought against him is.
Sorry, if we give this kind of a stay, then nothing will work.
Exactly.
My lord,
I can understand you being disqualified or that person being given.
That has been different footing, your
And
lordship.
out here, the financial bid has not even been opened. You want to be the super body saying that no, he should go, he should remain.
my lord, why should why
And they are an interested party also.
Yes, my lord, why should a bidder be pitted against, a financial bid of a bidder be pitted against a person who is expressly, palpably not qualified? My lord, somebody swearing an affidavit in the month of
That
February.
affidavit was sworn
When-
because this is retender, lordship. Earlier tender, every bid was rejected, your lordship.
Now,
The
my lord,
retender.
This is a retender.
if
They have not
this-
stated
if
that
this-
is a
if this-
retender.
He's submitting on instruction, my lord, then my lord, let me, my lord, February and August, 6 months in between, my lord. Then all these facts pertains to 6 months prior. That I have no case against me, not being debarred, not.
Have you submitted the earlier NIT? Is it here?
No,
No, earlier NIT is not here because I
even
have
he has
submitted
annexed
the
his documents
NIT,
also.
Which was,
Huh?
Even his technical bid documents, the petition even are annexed.
no, my
Yes.
technical, because I am qualified, there is no, I am.
Then in that case, the right is also qualified.
As per your. So if you
Right,
have challenged-
right. Heard Mr. M. Biswas, learned counsel for the petitioner, who submits that the petitioner had participated in the NIT dated 24/7/2024 for grant of IMFL retail off license in the district of Lakhimpur for shop number LKP 8 located at Narayanpur town. So, sir, the grievance of the petitioner is that despite the technical bid of the respondent number 6 being defective, comma, the technical bid of the respondent number 6 has been declared to be responsive by the authorities. He submits that the that the technical bid of the respondent number 6 should be declared unresponsive and the financial bid of the respondent number 6 should not be opened. He also submits that the respondent authorities have completely ignored the requirements, the mandatory requirements required of a bidder in respect of the respondent number 6. And they have allowed the respondent number 6 to pass the technical bid evaluation stage in the absence of relevant documents and information to be provided by a bidder. You file an application till it is decided, then
Fine, man. I'm applying.
Application before the authorities regarding for level.
Superintendent will, I'll file an application, let me make an input, that's fair enough, man. That will solve both the. Till then, I'll file within 2 days, man, from today.
what have I said? They have filed. Push-up, by bidder, push-up. Next para. The petitioner's counsel submits that due to paucity of time and the fact that the financial bid of the bidders is to be opened shortly, he did not file any representation with the authority. First off, however, no, first off, that's all. Then Mr. R.R. Gogoi, the learned counsel for the excise department, submits that the petitioner's grievance that the petitioner should have first approached the respondent authorities with a representation regarding his grievance. He submits that as the petitioner has not approached the respondent authorities, the present writ petition can be disposed of with a direction to the petitioner to submit a representation which will be disposed of by the respondent authorities within a specified time period. Mr. M. Biswas, the learned counsel for the petition, submits that he has got no objection to the proposal set forth by Mr. R.R. Gogoi, learned counsel for the excise department. First up, next para. In view of the consent of the parties, this writ petition is disposed of with liberty being given to the petitioner to submit a representation with regard to his grievance to the
Respondent number 2, the superintendent of.
to the respondent number 2.
Let it be respondent number 3. He's the author of the tender, like district
To
commission.
the respondent number 3.
This is the chair. He's the chairman of tender committee, Lordship.
So-
The district commissioner.
Okay, to the respondent number 3. Within a period of 2 days.
2 days, your Lordship. And we'll take a call within.
To the period of 2 days from today. From today.
Of the date of receipt of this.
Full stop. Thereafter. Okay, within a period of 3 days. From full stop. Thereafter, the respondent number 3 shall take a decision on the petitioner's representation and communicate the decision to the petitioner. Full stop. Till a decision is taken by the respondent number 3, comma, status quo with regard to the tender NIT dated so and so shall remain. So that way you can challenge him, challenge it properly.
Obliged, Lord.
Lordship, I pray for some time to file affidavit.
Yeah, for respondent number 6.
PTC
Yeah, file your affidavit.
has to file affidavit, basically this is regarding records matter. Why he has not been given an all matter. Immediately they file matter, we'll file affidavit. We're waiting for that.
So your bid is in excess of the 25%.
But
Valid.
that clause has been apparently misinterpreted matter. That clause, the way they are interpreting that is not the import of the clause matter.
When are you filing your affidavit?
Lordship, fix the matter immediately on reopening, Lordship. I will file immediately.
Okay. Mr. B. Chowdhury, Land Standing Council BTC. Submit that he will file affidavit in a position within 2 weeks. Mr. B. Chakrabarti, Land Council for the respondent number 6. Also submit that he will file affidavit within 2 weeks. List the matter on. What is to be done here, madam?
Lordship, as per our instruction, we have already forwarded the monitoring status report to the Brahmaputra board.
You have forwarded what?
Monitoring status report.
Monitoring status report,
Yes,
but
Lord.
what about the bill?
Part payment has been made to the petitioner.
How much is still balance?
Lordship, balance is 19 lakhs 62,414.
1962 440
414.
414.
Yes.
And how much are you claiming, madam? Now, so you have forwarded to the Brahmaputra board.
Yes, Your Lord.
Now, who's appearing?
Lordship, further payments will be made by the Jal Shakti board, Ministry of Jal Shakti.
Dashakti is not a party.
No, Your Lord. They have not made Jal Shakti as part.
But then it is your duty to provide all the details to Jal Shakti so that they submit they
We
give the
used to
funds.
forward the
Huh?
Lordship, we only used to forward the monitoring status report to the Brahmaputra board. And after,
Brahmaputra board, is it a party here?
no, Your Lord. And the Brahmaputra board will do the further.
No, but then you were the one who gave the work order to the petitioner.
Yes, Your
Then
Lordship. The,
you cannot wash your hands off.
but the
It
payments.
was because of you that the petitioner has used its own money.
Yes, Your Lord.
Then
But the payments are.
maybe
90% of the
you have
payments
got to
are-
now you are the channelizing agent. You see, you are the middleman, you can say, between Jal Shakti and the petitioner. Now, you cannot wash your hands off. It's your duty.
Lordship, we are doing our best to provide the funds to the petitioner. Lordship, even 50% payment has been made to the petitioner.
How?
Lordship, as
That
per
is
the
that's what
instruction-
I'm saying. You have done it without Jal Shakti being a party. Without Jal Shakti being a party, you have made part payment. Now, why don't you make full payment without Jal Shakti being a party? If you can do part payment, why not full payment?
Lordship, we have already forwarded the report to make the further payments.
Madam, you have to pay.
State share has been made.
How much was the bill of the petitioner?
Lordship, as per my instruction, 39 lakhs, 37.
And out of that, you have paid 16 lakhs or 19 lakhs.
We have made a payment of 19 lakhs 75,000.
Why did you make 90 lakhs out of 36 lakhs? State share would have been just 10%, 3.6 lakhs. Why did you pay 19?
Who wants to receive the payment?
What to do, madam?
Lordship, without Jal Shakti, we won't be able to make the payment.
Now you see the problem, you see the thing is that the order passed by this court,
So,
now that has attained finality, you have no challenge it. And what does the order say?
we have already filed
Okay.
review petitions. Lordship, recently we have filed review petitions against such cases in which Jal Shakti is not made party.
But is review is
Has
the
been
review
disposed.
maintainable?
Yes, Your Lord.
The court has allowed.
Yes, Your Lord.
Then why don't you file one here?
Yes, Your Lord. We have already filed a review petition for this case also.
Yeah, file. Okay,
Yes,
is there a review petition? That's what she's saying. Can you give us the number?
Lordship, recently we have uploaded. Lordship, in the next location, I will provide the number.
No, okay, you have filed a review.
Yes.
Miss D. Jain, Learned Counsel for the Water Resource Department submits that the payment of the contractual dues has to be given by the Ministry of Jal Shakti. She also submits that a review petition has been filed for impediment of the Ministry of Jal Shakti in WPC 4734 of 2021. Correct?
Yes, sir.
She submits that she will provide the details of the same on a subsequent date. This is the matter when
After like
this is the matter out of which. Give a date.
oblige the Lordship.
Then the document is more legible.
Item number 18.
My lord, I am the private respondents, 4 to 13. I have filed my wakalat number. So give me some time so that I can go through the record and file one reply.
Affidavit.
Yes.
Yeah, fine, but the lordship has observed the lordship is considering the intimate today, because till that my lord, it's an admitted that no work order has been issued. From that affidavit in opposition itself, the department certificate, my lord, also that there given a total go by to follow the case. So I don't have any objection in vices affidavit,
But the problem is this,
some protection may be.
You have been allotted the work order.
No, my lord, empanelment.
it is an empanelment.
My lord, we are yet to, my lord. My lord, though there is no stay order by this honorable court, my lord, but still, my lord, we are holding it unofficially, my lord. I have advised them, don't go ahead, because there is a direction on the last occasion, my lord has observed that on the next day, interim will be, my lord, considered. So I told them that hold the thing for some time until and unless the honorable court passes an order, either way, whatever it is. The honorable court may allow the interim, may reject also. So that is why you hold it. Don't issue any work order. That is not unofficially, but I have told them and they are holding it. My lord, this is off the record, but I'm giving my lord an assurance.
So they will continue to do it or what?
My lord, I can give assurance, my lord. They will, I told my friend also, don't worry about that, because I have told them. There is a line in that. Because my lord, this is the communication that you also maintain. Because my lord, when already my lord has written in the order that on the next day, interview will be considered. So I cannot advise them, my lord, that you go ahead. That will be, my lord, not ethical on my part.
For that, I am also suffering. But in this case,
They did not, that is why, my lord, they have come running. this,
That is
my lord,
correct, my
private
lord.
Respondent, why they have come?
yes,
running?
yes,
So,
yes.
my lord,
And I assure that I will be filing within 1 week, madam.
My lord may not pass any order, but I give assurance, my lord, nothing is going to happen, my lord, in 1 week until that it is decided, my lord, on the interim. That is, my lord, I have given them, my lord,
My lord may fix this matter on 1st of October.
It is only for empanelment.
empanelment.
Why are you against their empanelment?
No, no, my lord, it is we shall waive decided.
No, I don't know why he's come, why has he come into the,
No,
That is exactly, my lord. They have put,
So what's intention is that the exemption that have been given to them has not been given to them.
okay, that's the only thing.
yes, but there is two things. First thing, whether they have committed any wrong. Second thing, they have shown that we have committed some wrong. They have their specific allegation against us. And I have all those-
They are saying that, they are saying that we are in the same boat as you. But you have been, your bid has been accepted, while their bid has not been accepted.
No, my lord, not on the same boat. That is the problem, my lord. Not on the same boat. Their points are different, my points are different. And in the paragraph number 15, they have category allegation against me. And against those documents, the department also, I have seen that department also filed one reply. And I have also all those documents showing that the respondent, private respondent number 4 to 10, 13, don't have any such committed some mistakes, my lord. So my empanelment, there is actually no problem.
No, they are not challenging your empanelment. They are
They
basically.
are challenging, my lord. That is the problem.
Is
That
it?
why
Challenging?
they are saying. They are challenging the whole process.
Just a minute.
Yeah, and the extent that we have been discriminated.
Only on that ground. They are basically saying that, yes, in a way, they are saying that if they are to be disqualified, you are to be disqualified.
No.
Correct.
That
That's
is-
what they say.
That is what, my lord, I am.
Okay, you
certified
file, you
opinion.
file. Mr.
DK Nath.
DK Nath. Huh? He's saying that nothing will happen.
Nothing is being.
I will record it. I will record it. Mr. DK Nath, Learned Counsel for the private respondent. Submits that he has filed Vakalatnama today.
Well.
He prays for a week's time to file affidavit on behalf of the private respondent. Then,
my lord will just observe that, my lord, earlier order, my lord, the
Yes,
hearing
yes.
will be
okay.
considered on the next day. That is enough, my lord. My lord, that is enough. My lord,
No, I'll be listing it next week.
my lord will next week, my lord.
I'm listing it next week.
I have no problem, my lord. My lord will just observe that interview will be, my lord, considered next week.
Okay.
No authority will go next week.
Today's Tuesday, no? Next Tuesday, right? List the matter on first. Interim order will be considered on the next day. The prayer for interim order will be considered on the next day.
Find this affidavit.
That is also correct.
Actually, I'm just waiting for that. All the things. I thought I'll dispose it of today, in fact.
Oh, it's a good day, my lord. Tuesday, it's a hearing day. It's a small issue, my lord.
That
That's
is
it, and my lord will dispute it.
I hope so.
Okay.
I was ready, my lord, but it's not.
But then ready to allow the writ petitions.
No, my lord. I will fight it. I will show. my
You'll
lord.
fight tooth and nail.
Yes, do the amendment.
Be happy if I'm empanelment. I do not have anything against him. If they discriminate, then I'll have to.
I will show my.
Oh, first I think we're feeling that that PK was firm and all of it. I don't think. Item?
My senior is suffering from viral.
Oh, who's your senior?
Yes, sir.
Unfortunately, his name is not here. Is he here? We have already adjourned this. No. Oh, okay. Okay, right. Adjournment prayer has been made on behalf of Mr. T.R. Sharma, learned counsel for the petitioner on the ground that he is unwell. It's a parted matter. Regarding what? Or the contractual dues or the. Do it for the APDCL. Good morning, okay, right. Right. Accordingly, leave this matter after vacation. Yes. Just put this up.
The petitioner is a grade 4 employee. It's a process server in the office of SDJ in Bokaja.
Yeah, what SDJM?
It's subdivision Judicial Magistrate Bokaja. Karbi Angle. A complaint was lodged against him on 16th of August 2021 for allegedly avoiding duty and misbehaving with the office staff lodging
Where is that page?
of the paper.
Paper book.
State number 19 annexure B lodging.
What paper book?
Not paper.
Complaint dated 16/8/2021. Yes.
And the allegation is of avoiding duty and misbehaving with the office staff lodging. May I read the complaint lodging?
Yes.
To the Honorable District and Sessions Judge Deepak Kaviramo. So with due respect, I beg to inform you that on 14/8/2021, the entire office staff was asked to reach the office premises at about 9 AM in order to do the preparation for the Independence Day celebration, scheduled on 15th of August 2021. But the delinquent Bharat Kalita, who was working as judge Bharat, refused to do so the allotted work, even though he reached office on time. Given one excuse or the other, he wanted to leave the court campus at around 11:15 AM. Since we have limited office staff, I, as the officer in charge, asked Bharat Kalita to leave only after completing the necessary work. But he retorted, saying that he would not do any work, and it is enough that he had come to court on his own. He further misbehaved with me in presence of other staff, Ms. Nitu Puthan and Pallavi Saitya, and further retorted saying, "Who are you to order me to work? I will not work on holiday, even when the district judge or the SSM orders me to work. It is enough that I have come to court on holiday. Therefore, finding no other way, I sometimes lodge this complaint, and I pray that your honor will take necessary action." Lordship, then thereafter he was show caused after this complaint, and the petitioner replied to this.
Where is the show cause?
Lordship. This is page number 22, Lordship. That is the show cause notice.
So show cause and complaint same day.
Yes, Lordship. It is on the same day, on 16th of August 2021. And you can read this Lordship, show cause.
Why not?
Sri Bharat Kalita Jadikar, Office of District and Session Judge, Kardiangam, Vicky. Whereas you have reported that you have avoided your allotted duty on 14/8/2021 and misbehaved the other staff, including officer in charge, which amounts to breach of official discipline and gross negligence of duty. As such, you are thereby asked to show cause as to why disciplinary action shall not be initiated by you by disobeying, violating the orders under Assam Discipline and Disciplinary Appeal Rules 1964. Your reply should reach the other side on or before 26/8/2021. Thereafter, we replied, Lordship, and the reply is in page number 23, Lordship. May I read, Lordship?
Yes.
To the district and sessions just before Kavya, reply to the Shoko's notice. With due respect, I would like to state that I, Sri Bharat Pandita, having been working as Jadikarak in the court of SPPM since 22/6/2021. As a reply to the Shoko's notice, I would like to inform you that on 14/8/2021 Saturday, I was called upon to attend court for preparation of Independence Day celebration. Hence, I reached the court campus at about 9:30 AM on 14/8/2021. At about 12:30 PM, when I told Lower Division Assistant Himanshu Sharma that I would like to go to my relative's home for lunch and doing some household chores. As my wife was not there, Himanshu Sharma told me to go only after blowing some balloons. I replied that I will go for a while and come back, or will do the work of blowing balloons early next morning. At that moment, he started scolding me and alleged that I was driven out from the headquarters at the by official order. I felt humiliated and got emotional. The incident happened outside the premises of the court, and there was no intention on my part to insult Himanshu Sharma. At the same time of incident, two other employees of the STZ court, Bokata, Pallavi Saikya and Vijay Kupal were also present. Thereafter, I did not leave the court premises and informed the SDVM regarding the incident. Above incident was unintentional, and I beg apology for it. So this was his reply, Lordship. Then, not being satisfied with his reply, Lordship, disciplinary proceedings were initiated against him, and the inquiry report was submitted against him, Lordship.
No, inquiry report, prior to inquiry report, memo of charge would have been.
Yes, memo of charge is there. The article of charge, Lordship, is page number 26.
Yes.
May I read the article of charge, Lordship?
Yes. Is this matter, is it a bench for matter?
No, Lordship. Since it is a High Court matter, Lordship, this matter is assigned before your Lordship.
Okay, okay.
From the district session plus to Sri Bharat Pandita Jadikarak disciplinary proceedings. You are hereby required to show cause under Rule 9 of Assam Discipline Rules 1964 as to why any of the penalties prescribed under Rule 7 of the aforesaid rules should not be inflicted on you on the following charge based on the statement of imputations of misconduct or misbehavior attached herewith as Annexure 1. A list of documents by which and a list of witnesses by whom the article of charge are proposed to be sustained are enclosed as Annexure 2 and 3 respectively. Article of charge that you, while working as Jadikarak in the office of SDVM Bukata, Karbi Anglong, disobeyed the orders of the authority by refraining from doing allotted work on 14th August 2021. That you stated to the complainant Sri Himanshu Sharma that it was enough that you had come to the office on equality, that you argued with the complainant and misbehaved and humiliated him in presence of Srimati Pallavi Saikya and Vijay Kupal, that you stated to complainant that who he was to order you to work and that you should not work in equality, even if you were directed by the district judge and SDJM of the Punjab. That the above act on the part amounted to misconduct and failure to maintain discipline, propriety, and integrity of the office. You acted in a manner unbecoming of a government servant, violating the established norms.
Rule 7, Rule 9. Rule 7, Rule 7.
This was the charge, Lordship. First was that he did not do the allotted work. They were allotted to him, and the second was that he misbehaved and humiliated the complainant, Lordship. This was the charge. And thereafter, Lordship, he was asked to give a statement of defense, which he did give, Lordship. The statement of defense is Annexure 5, page 28 to 32, Lordship. Annexure F, page 28, that is a copy of statement of his defense, Lordship. Not being satisfied, Lordship, with the statement of defense, disciplinary proceedings were initiated against him, Lordship. That is page number 33, Lordship. copy of order to initiate disciplinary proceedings. Thereafter, Lordship, inquiry report was submitted on
No,
11
this page 33, what is this? What is this?
page 33, that is the copy of the order by the district judge to initiate disciplinary proceedings. May I read, Lordship? Page 33.
Yes.
Shri Bharat Kalita Gadikarat has submitted his written statement showing that he is disobeyed the order of the authority by refraining from doing the allotted work on 14th August. And he argued with the complainant Shri Himanshu Sharma and misbehaved and humiliated me in presence of Srimati Pallavi Saikya and me. I have gone through the statement at length. He has denied the charges drawn up against him. I am not at all satisfied with his reply as the charges are grave in nature and his reply does not negate those charges. Accordingly, I deem it fit and proper to initiate disciplinary proceeding and inquiry against Bharat Kalita as contemplated under Rule 9 of the Assam Service and Discipline and Appeal Rules. Itself is a disciplinary authority. It would be wise prudent that an inquiry be conducted by some other officer. Hence, Mohammed Amin Ansari, civil judge cum assistant to Sessions Judge Karbi Agam, is hereby appointed as inquiry officer under Section 9 of the Assam Service Rules to conduct the inquiry of the departmental proceeding drawn up against the Bharat Kalita of this establishment. Further, Srimati R. Vedu, Munsif cum KFMC Karbi Anglong is appointed as the presenting officer to present the case to support the charges before the inquiry officer. The inquiry officer is directed to submit his report at the earliest, preferably within a period of 1 month from the date of receipt of the report file. It is made clear that Shri Bharat Kalita Gadikarat is permitted to inspect and take extracts from relevant reports in case of desires prior from time to time. He is also entitled to engage a defense assistant so applies for the other side, but the defense assistant has to be in the So, Lordship, this was the order to initiate disciplinary proceedings. Thereafter, Lordship, the inquiry report was submitted. That is an extra X series, Lordship, from page 35 to 48.
That is the inquiry report.
Yes, Lordship, from page 35 to 48. That is the inquiry report.
So you have been found guilty.
Lordship, I have been found guilty by the disciplinary authority, Lordship, and hence I was imposed punishment under Rule 7(2) of the Assam Service and Disciplinary Appeal Rules 1964. And the order, Lordship, of imposing punishment is in page number 59.
No, sorry, the inquiry report was furnished to you.
Lordship, it was punished. There is no violation. I have not.
So all the procedural requirements have been followed. So what remains? Only with regard to what? Facts.
Regarding not facts explicit, Lordship, I'm denying that I have made such statement, Lordship. And assuming, Lordship, even if I have assumed that I have made such a statement, Lordship. So the inquiry officer, Lordship. So there were two charges. The first charge was that I have not done my allotted duty. And the second charge, Lordship, is that I misbehaved with the officer. So regarding the first charge, Lordship, in the inquiry report, there was no finding. The inquiry officer himself accepted that there was no allotted duty, no particular duty was allotted.
You had to blow balloons.
Lordship, I had to blow balloons. I have not done that, Lordship, because I had some medical conditions.
Where have you stated that? Did you bring it up before during the inquiry proceeding?
Yes, Lordship, I did bring.
Now, what did the inquiry officer say?
Lordship, may for a moment peruse page number 48, Lordship. Here read para number 14, Lordship. The PW3 in her testimony stated that when the complainant asked the delinquent not to go home, the delinquent retorted that he had done his work and there was nothing more left to be done. That the complainant told that there were some balloons which were to be blown, but Bharat Kalita told that he cannot blow balloons as he had breathing problems. However, the complainant then asked him to do some other work, but delinquent replied that he would not do any more work and that it was more than enough that he had come to work on a holiday. Thus, from the testimony of PW3, it is revealed that only specific work that the delinquent refused to do was blowing off balloons, which he refused to do because of his breathing problem. The PW3 also stated that when the delinquent told that he cannot blow balloons due to his breathing problem, the complainant asked him to do other work, but then PW3 did not specifically state as to what other work was asked to be done. Thus, it is not clear as to what work the delinquent refused to do. Then, Lordship, the next page, para number 15, Lordship. May I read, Lordship?
Yes.
The complainant PW2 clearly stated that the delinquent went to tent house with him from the court campus and then returned back to the campus with him, and that the delinquent wanted to leave for home only at 11 a.m. Therefore, I am of the considered view that there is no cogent evidence on record to show that the delinquent willingly disobeyed the complainant or the authority. There is no cogent evidence to show that the delinquent refused to do any specific duty or task allotted to him on 14/8/2021. So, Lordship, this charge was not moved, Lordship. Now, the only charge, only allegation, Lordship, that was against him, the only adverse finding, Lordship, in the inquiry report was that the petitioner was involved in a altercation with the complainant.
Misbehaved.
Misbehaved altercation. Actually, Lordship, he has uttered the word toy. So toy in Assam means actually, Lordship means you. I don't know what is the equivalent, Lordship. This toy actually is not a vulgar word. So it is a word which we address you to our like colleagues. So since the complainant and
So it was like an insult.
insult, but then this word is not necessarily derogatory, Lordship. It is what we commonly address. So only because of that word, Lordship, which I deny, but even for the sake of argument, even if I accept that I have like uttered that word, Lordship, so it is not that grave, Lordship. The punishment which is given to me of withholding 3 increments, and Lordship, so that is in my humble submission, that punishment which is given to me is very grave and harsh vis-a-vis the charge.
So it is disproportionate, you mean?
Disproportionate. It's extremely disproportionate, utterly disproportionate. And therefore, Lordship, and one more thing, Lordship, if for a moment, very space number 59, Lordship. That is the order imposing punishment on me. Lordship, the last paragraph, Lordship,
Yes,
page number 59.
yes.
Hence, I impose punishment to the delinquents regarded Kalita by withholding 3 annual increments with effect from the date of this order. For Lordship, it is not mentioned whether it is with cumulative effect or without cumulative effect.
But without cumulative.
Without cumulative effect, Lordship, and even if it is without cumulative effect, it is not given like the prescribed period, Lordship. So if that is the thing, Lordship.
What is the prescribed period?
Like for how long this annual increments will be withheld, Lordship?
3 increment, Lordship. 3 annual
Increments,
increment.
but for how long? Not
No, so as soon as till the third one, only till the third one. It doesn't mean that they have to give you a certain number of years. So say the first increment is supposed to be given to you this year. The next year after that.
at all it is given, it may be clarified, it is without cumulative effect, Lordship. And in my humble submission, it is disproportionate, Lordship. Maybe some admonition would have done. He's just a young person of 34 years. His entire career,
34 years is not young.
Lordship, his entire career is there, Lordship.
When he can, if he can talk back to his superior, it'll be a problem. How do you control such a person?
Some admonition would have done. Lordship is given withhold 3, then he
You see, the issue is this. Now, according to you, only one fact has been proved, that misbehavior part has been. Now, that now is a question of fact. And the Supreme Court has held that, I think in BC Chaturvedi's case, it has held that the disciplinary authority the sole judge of facts. In that case, we cannot sit in appeal over the merits of their decision with regard to facts. So that aspect now is proved. So the only, and as you said that there was no infirmity with the procedure followed. So now the only thing that remains is whether the punishment was disproportionate to the offense. Now, I think there is a judgment of the Supreme Court which says that it has to be unconscionable to the court to take a different view. And even if this court is to take a different view, the issue should be sent back to the disciplinary authority to take a decision as to whether they are entitled to be given a lighter sentence or a lighter penalty. We cannot, now our hands are tied, we have got no power. It's
It is a minor punishment, not major punishment.
minor punishment. Let me see whether it's a minor punishment under Rule
Rule 7.
7.
It's 7-2.
Withholding of increments of promotion.
Minor punishment.
So it can be reduced to 2 also.
I have given a judgment, Lordship. Lordship, may kindly stay with Lordship.
Ah, yes.
Para 42, Lordship.
Yes.
Supreme Court
You can
judgment,
place
Lordship.
all the judgments as all one.
Para 42.
Para for it. Yes.
It is now well settled that the scope of judicial review against a departmental inquiry proceeding is very limited. It is not in the nature of an appeal, and the review on merits of the decision is not permissible. The scope of the inquiry is to examine whether the decision-making process is legitimate and to ensure that the findings are not bereft of any evidence. If the record reveals that the findings are based on some evidence, it is not the function of the court in a judicial review to reappreciate the same and arrive at an independent finding on the evidence, Lordship.
Yes, so it's the same.
Yes.
These have all been enunciated in BC.
If there is no
Chaturvedi's
procedural
case.
infirmity, Lordship,
Huh?
if there is no procedure lapse, Lordship. Because, Lordship,
Yes, sure. Yes.
Draft High Court judgment, Lordship. Lordship, paragraph number 6, Lordship.
Yes.
I have liberty to mark, Lordship, I may be.
Okay, no problem.
Lordship, the punishment, Lordship has got that. Paragraph number 6.
Yes.
The punishment which has been imposed, stoppage of 3 increments with future cumulative effect would be a minor penalty under the so and so, which enumerates withholding of increments of promotion as one of the minor penalties. The word withholding of increment are not circumscribed, and there is no reason to infer that a minor penalty of withholding of increment should be for a particular period. On the contrary, since the expression withholding of increment is not hedged by prescribing any period, the obvious meaning would be that withholding of increment would have future effect, unless for good and sufficient reason the competent authority may limit its effect for a particular period. Then, Lordship, this paragraph only, the last 4 lines, Lordship. As observed above, there is no word to limit the expression withholding of increment of pay, and therefore the expression should be given its full play, which would necessarily mean that an order of stoppage of increment was intended to have a permanent effect, unless the competent authority wanted to impose the penalty with less rigor by prescribing the period during which such order would have been made. Lordship, then, paragraph number 10, Lordship.
Yes.
The only question that now remains is to be considered is whether the punishment imposed on the petitioner of stoppage of 3 increments with future effect can be said to be harsh. There is no dispute about the proposition that if the court finds the punishment to be disproportionate or harsh, it can interfere with it in the exercise of its writ jurisdiction. In the case of so and so, the only fault that was found was deliberate was that he did not shift his headquarters or place of residence from so and so when he was transferred, and the penalty which was imposed on him of withholding promotion for 5 years was reduced by the appellate authority to the penalty of withholding of 2 increments with future effect. So this was done, Lordship. And then Lordship, paragraph number 11, Lordship. There would be no point in sending the matter back to the delinquent authority because the petitioner is already retired. So in that case, in this case, Lordship, he has retired, but in our case, he has not retired, Lordship. And therefore, the appellate authority only modified the punishment in this case. Lordship. This is my humble submission. I leave it to your Lordship. Possible to reduce, Lordship.
Because there is no procedural lapse, Lordship. Everything has been done, Lordship. Law.
You see, the problem is our scope is very limited now.
And he is not also filed the appeal, Lordship, as per section 13 of the disciplinary appeal rule, Lordship. There is a provision, Lordship, for appeal against the penalty order.
No point sending him to file an appeal. Only thing is that, can it be, does it shock the conscience of the court? You see, the punishment imposed, does it shock the conscience of the court? That is the test.
Just for applying that word, Lordship, which is not there.
Not,
I do
not
not
on
know.
this whole, Lordship.
Huh? Let us see what
Lordship, may kindly see the page 47, Lordship. He has already stated that Pallavi Soikia is also present at the time of incident, Lordship. What Pallavi Soikia has said, Lordship, may kindly see the 47A.
yes.
He further told that SDJM আৰু DJ কোলেও মই বন্ধৰ দিনা কাম নকৰো. That means if SDJM or district judge also said, I will not do anything.
No, that is just to make his argument stronger. But what did he tell this fellow? Sorry, because this. Sorry, kun muk kam kar bole ko bole.
Page number 41, Lordship. And read, Lordship. That page number 41, Lordship. Noi kun hoy, moi tur under of kam kori thoka nai nohoy. Took moi prothom dinor porai notice korisu. Bondhor dina SDJM aru session judge koleu kori koloi nai. Toi ji koro kor moi kam nokoru, mane nokoru. So Lordship, if translated, it means that who is he? The complainant is not the authority that he is working for, and the delinquent.
This is total defiance, insolent. Total defiance. If you can't control your staff, then what will happen? Supposing someone in your chamber says that on Saturday tells you, no, today is Saturday, I'm not going to work. I think you'll have a very different view of that person. Difficult, madam. The thing is that for the punishment to be said that it is disproportionate, this court would have to come to a finding that it shocks the conscience of the court. No, not very shocking, harsh, no doubt. It appears to be harsh, but I don't think it's shocking. And it's a minor punishment.
Minor punishment. Until and unless there is no procedural lapse, Lordship.
Huh?
Until and unless, Lordship, there is no procedural lapse on the
No,
part
but
of the
then,
departmental authority, Lordship.
You see, one thing, madam, one thing is that to insolently say that he will not work while everybody has gone there on that day to work. Because there are times where you have got to work beyond your office hours also. That even the staff. For judges and everyone else, so it's a different matter. We all work, the lawyers also, we work every day. But for these staff, sometimes on special occasions, they've got to work. Anyway, that's all. You're from here. Who's your senior?
I talked to you over phone, Lordship, once, but I have not met you personally.
Okay. Okay, right. Heard Miss
Debashri Saikia.
Debashir Saikia, the Learned Counsel for the. Is this your case or for your senior? What is this?
Lordship, this is my case.
Okay.
Senior is DK Mishra.
This item 15.
Yes.
Huh? Heard Miss D. Saikia, Learned Counsel for the petitioner. Also heard Mr.
N.K. Sharma appearing on behalf of Mr. H.K. Das standing on Silvergate.
N.K. Sharma appearing on behalf of Mr.
H.K. Das standing on Silvergate.
H.K. Das, standing counsel, Guwahati High Court. Is it?
Yes, Lordship, for respondent number 2 to 4.
That is point number 2 to 4. Who is for 1? Miss Udas appears for point number 1. That's all, madam? No one, nothing else? Okay, right. The petitioner is aggrieved with the impugned order dated 25/2/2022, by which the petitioner has been imposed with the penalty of withholding 3 annual increments pursuant to a disciplinary proceeding initiated against the petition. Next paragraph. The petitioner's case is that a complaint had been submitted against the petitioner by
16/8/2021.
huh?
16/8.
Just a minute, Mr. Counselor. By one Himanshu Sharma. What was he? What was Himanshu Sharma?
LDA.
Who was a lower division assistant in the court of
District and Sessions Judge Difu Karbi Anglo.
District and Sessions Judge Difu Karbi Anglo. On the ground that for the Independence Day celebration to be held on 15/8/2021, the staff and officers of the district judge Difu Karbi Anglo were to reach the office campus, the court campus at around 11:15 a.m. Is it?
At around the
At around what time?
court campus at about 9:30 AM.
At about 9:30 a.m.
14.
on 14/8/2021 to make preparations for the Independence Day celebration. Gustav. However, the petitioner failed to do any work on the said date, even though he had reached the court complex on time. Further, he told the complainant that he would not do any work on a holiday. Next paragraph. Another. The complaint was addressed to the Honorable District and Session Judge Difu Karbi Anglo. Next paragraph. Pursuant to the complaint dated 16/8/2021, a show cause notice dated 16/8/2021 was issued to the petitioner by the district and session judge, Difu Karbiano, wherein he was asked to show cause as to why a disciplinary proceeding would not be initiated against him by avoiding his allotted duty on 14/8/2025 and misbehaving with the other staff, including the officer in charge, which amounted to breach of official discipline and gross negligence to duty, the same being in violation of the Assam Service and Disciplinary Appeal Rules, 1964. Next para. The petitioner submitted his reply dated 25/8/2021. Stating that he would do the work of blowing balloons only after doing some household chores which were to be done in his house. The petitioner also stated that as there was no intention on his part to insult the complainant, also stated that there was no intention on the part of the petitioner to insult the complainant. Yes, sir. However, as he had been scolded by the complainant and had been driven out from the court complex, he felt humiliated, due to which what? This is not, it's not making, there's no connection. He felt humiliated, and so what happened? But that's not reflected here in this. In the Assamese version, it might be there, I don't know.
Regarding the altercation, Lordship.
No, in this page 23, in this reply to the show cause, it's not making sense.
I got emotional. That is it.
Okay, what have I said? Due to which he got emotional. Huh? Due to which he got emotional. That's all. Yes, Mr. H.K. Das, what is there to say? Who am I? Should I reflect his name or your name? Your name.
Up to you, Lordship. Lord, the issue is, Lord.
No, issue is very clear.
Absolutely. The charges were proved on the basis of material evidence available on record, my lord.
Should we lessen the punishment by 1 instead of 3, make it 2 cumulative?
Lord, that power is also very
I
limited.
know, very limited.
That power is.
That is also very limited.
Yes, my lord. Quantum, my lord.
That also has to go to the disciplinary authority.
So I don't want that your lordship pass some order, my lord, because it's a law ultimately. Which are.
We can mold it.
Otherwise, my lord, only 2 annual increments, no 3 annual increments,
Yeah.
no cumulative effect.
So he will,
Going by the
so no loss actually.
No cumulative effect, only 3 increments, it's a minor penalty, my lord.
So he will get it back later on.
Yes, because the increments will, my lord,
Will
again,
come,
will come,
will come again.
yes.
Pray that that will be clarified, Lordship.
Okay. Okay, I'll
No,
clarify
it's
that.
there only, all, in the order, it's not there.
Written anything.
Yes, yes.
Without.
So if not,
Okay, we'll clarify so that she can show her client that look.
Yes, 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 yes. Because if it's not written cumulative, then it cannot be.
Correct, correct, correct.
Yes.
But she has got to show that, look, no, madam, the problem is, like I said, the law
Absolutely.
is very clear that it has to shock the conscience of the court. Then only we can interfere with the penalty. And that also, we have to send it back to the disciplinary authority, who will decide whether to, you know, yes, who they will decide as per the as per the as per the consideration given by the court. But actually, it all goes back to, we cannot decide as to what should be the penalty. I cannot say that it should be. I can say that maybe you should consider giving less. Otherwise, it'll amount to, me changing the penalty imposed.
Stepping into the shoes of the.
Huh?
Stepping into the shoes of the.
Yeah, I'll be
disciplinary
stepping into the shoes
Yes.
of that authority. I forgot the judgment, that Raj Kumar or Raj. what
Yes,
is it?
sir.
I don't remember it.
এই চতুর্থী বহুত পুরোনো, নতুন actually. কিন্তু
So I haven't done service matters in a long time.
একটু ফাইল রাখো আমার।
I was doing criminal matters, lordship. This is the only like service matter I'm doing on my own.
Oh,
Unless I can.
yeah, whose daughter? PK Saikia, you said?
I'm in the amicus curious, so I keep on
That PK retired. Okay. Yeah. We sat together.
like his brother. He keeps sending.
But criminal sitting as the junior judge, it becomes very boring. Criminal bench as it
Tremendous patience is required.
criminal bench as it is quite slow. And as the second judge, so we have got more even a lesser role to play.
It was mostly in criminal bench only.
Ah,
He used to sit.
yeah. Anyway, where are we? Good. Motion. Full stop. Next para. The district judge, Karbi Anglong, on considering the show cause notice and the reply made by the petitioner, held that he was not satisfied with the reply made by the petitioner to the charges that had been stated in the show cause reply. Accordingly, the district judge deemed it fit and proper to initiate disciplinary proceedings against the petitioner under Rule 9 of the Assam Services Discipline and Appeal Rules. Hereinafter referred to as the 1964 rules. 1964. Next. In the disciplinary proceeding held against the petitioner, the inquiry officer came to a finding that The petitioner failed to maintain discipline and propriety discipline and propriety and acted in a manner unbecoming of a government servant. Full stop. Thus, the disciplinary inquiry officer came to a finding that the petitioner was guilty of misconduct in misbehaving and humiliating the complainant. The next para, the inquiry report was thereafter sent to the petitioner to file a representation, to enable him to file a representation against the same. Full stop. After the petitioner submitted a representation, submit a representation, the disciplinary authority came to a finding that the misconduct of the petitioner had been proved and where is the impugned order?
Page 59.
Check A. 59.
Whatever I said, whatever I said. Have improved and the petitioner was guilty of insubordination, indiscipline, which amounted to misconduct. So he was accordingly imposed with the penalty of withholding 3 annual increments with effect from the date of the impugned order dated 20/5/2022. Next paragraph. The petitioner's counsel submits that though there was no procedural lapse while conducting the disciplinary proceeding against the petitioner, the penalty imposed upon the petitioner was disproportionate to the offense, and as such, the petitioner should be, and as such, the penalty should be reduced. She also submits that the penalty imposed upon the petitioner has not been clarified, inasmuch as there is nothing to show that the withholding of 3 annual increments would be with or without cumulative effect. I have heard the learned counsel for the part. No, before that, Mr. Huh? Who? I don't know.
No, let him.
Okay, Mr.
NK Sharma.
N.K. Sharma, the learned counsel for the High Court. Learned counsel appearing for Mr. H.K. Das.
Yes.
Learned counsel for the High Court. Learned standing counsel for the High Court. Submits that there is no procedural lapse in the disciplinary proceeding conducted against the petition. Further, when the misconduct has been proved on the part of the petitioner, comma, the imposition of the penalty by the disciplinary authority should not be interfered with, comma, as the punishment was not disproportionate to the charge framed against the petition. That's all. I have heard the learned counsel for the parties. As has been, no, next para. I have heard the learned counsel for the parties. It is an admitted fact that no, they don't say it is not disputed by the parties that there was no procedural lapse in in conducting the disciplinary proceeding. With regard to the finding of guilt against the charge framed against the petitioner by the inquiry officer and the disciplinary authority, comma, it would be profitable to refer to the decision of the Supreme Court in the case of B.C. Chaturvedi versus Union of India, 1995, so and so SC, 6 SCC 749, comma, where the Supreme Court has held that the disciplinary authority is the sole judge on facts. In the present case, it is not in dispute that the petitioner had what rebuked the complainant. That doesn't make any anyway. Puस्तक. As such, this court is of the view that there is no reason for this court to come to any finding that there was any infirmity with the decision of the inquiry officer and the disciplinary authority to come to a finding that the petitioner was guilty of misconduct. Next paragraph. With regard to the submission made by the petitioner's counsel that the punishment imposed upon the penalty imposed upon the petitioner was disproportionate to the offense, it would be profitable to refer to the decision of the Supreme Court in the case of J.P. Saraswat. I'll give you the dictation data. Wherein, Saraswat, something versus Saraswat. Wherein the Supreme Court has held that judicial review is permissible in very rare cases where punishment is disproportionate to the established charge. that it would appear unconscionable,
11.4 FCC, 11.4 FCC 5.4.
that it would be, that it would,
Right.
that it, no, which should appear unconscionable to the court,
5.5.
which should appear unconscionable to the court. Full stop. In the present case, the penalty imposed upon the petitioner is a minor penalty. And keeping in view the fact that the petitioner has been found to be guilty of misconduct. This court is unable to come to a finding that the penalty imposed is unconscionable and slash or shocks the court, shocks the conscience of the court. Yes. Looking for some judgment, right? Huh? State of Uttar Pradesh, huh? State of Uttar Pradesh and others versus JP Saraswat, 2011 4 SCC 545. Okay. Then says here, Acha, it says, wherever I said, unconscionable, no, I said? No, before that, in JP Saraswat. Mm. Unconscionable and actuated by malice, and actuated by malice. Full stop. In the present case, there is no averment to the effect that the penalty was actuated by malice. Full stop. Huh? Okay. Then you continue. Okay. And what is that other judgment that it has to go back to the authority that
In the event of, yes, my lord.
in the event of coming to a different finding?
I'll just check, my lord, one judgment, SR Tiwari I have got, my lord. I just check whether that has been said or not.
Is that? Let me see my book here. Okay, anyway, so where am I? Full stop. Uh, before, uh, closing with the present case, comma, this court would, it is clarified that the penalty imposed upon the petitioner, that is withholding of 3 annual increments, is not with cumulative effect. Are you sure you want that? Is not with cumulative effect. First up, next para, in view of the reasons stated above, comma, this court is not inclined to exercise its discretion in the present case. The writ petition is accordingly dismissed. Oh, these are your judgments. I forgot to mention them. Wait a minute, just a minute. Okay, wait. The judgments and you just put you had shown me which one?
2023.
Gujarat. No, I don't think it's relevant now, this one, okay? Then in the other one, you just put after in as my submission, yeah? In the case of State Bank of India versus AGD Ready, 2023 SEC Online SC 1064, the Supreme Court has held, para 42, okay, take it. No. Because I've said that no conscience, no.